Hello again. Now, the Senzo Meyiwa Murder Trial underway in the North Gauteng High Court in Pretoria. The first witness, Forensic Officer Thabo Musia, concluded his testimony yesterday. And the second witness, Sgt Patrick Mlungisi Mthethwa, taking the stand today. Let's bring in our reporter, Silindelo Masikane, who's been watching the court proceedings since they began and still today with the new Sgt Mthethwa on the witness box. I'm pleased I saw that smile, Silindelo Masikane. Sorry. So what's happened in court today?
Well, Bradan, officially we are in the midst of the testimony of the state's second witness, that is Sgt Patrick Mlungisi. We know that he is one of two police officers who was on duty on the night that Senzo Meyiwa was shot and killed, stationed at the Vosloorus police station, telling us in court that he began his duties with Mathebula at around 6 p.m. that evening at around 5 minutes to 9. That is when a call was received from the call center with regards to what he described as a shooting in progress, which he and Mathebula had to go and attend to. And of course, he has now detailed what happened when they left the police station in terms of how long it took them, about 5 minutes to get to Nomzamo Street. He says when on their arrival, they were met by a man called Temba, who claimed to be Kelly Khumalo's brother, saying that he also did not have much details around what happened and that those who were in the house had rushed to the hospital. Now, I want to bring in our legal expert this afternoon, that is Mr. Marius du Toit. Thank you so much for your time this afternoon, Marius. Maybe let's just start with the fact that during the testimony that we've heard from Sgt Mthethwa, he and his colleague did not secure the crime scene on their initial visit, and in fact left the crime scene to go and find those who were in the house at the nearby hospital, where we're told Senzo was rushed to in order to save his life. They're saying that only on their second visit, when they had come back from the hospital, was the crime scene actually secured. Is this something that's normal in terms of procedure, and just how critical is it, the work that is done initially by those police officers who arrive first on the scene?
Silindelo, it's always important to secure a crime scene, and the reason for that is the moment we deal with evidence like forensics, ballistics, fingerprints, when you deal with those sort of evidence, it's important that that evidence be contained at the crime scene in a pristine condition. The moment you allow people to walk over the crime scene, to enter the crime scene, it contaminates the crime scene. You know, if I, for argument's sake, walk over the crime scene, and let's say in this instance they would have realized it's a crime scene because a person had been killed, they ought to have immediately secured the area. They ought to have made sure that nobody enters or leaves the building, that the area is cordoned off, so that when the forensics arrive there and they, for argument's sake, find blood spatter, or they find, for argument's sake, a cigarette butt, or they try and lift fingerprints, that we can say that that fingerprint or blood spatter or DNA evidence that they extract from a cigarette butt, that evidence was for sure left by the people who were at the crime scene at the time when the crime was committed. Because that's ultimately what you want to draw inference from. The moment you can't do that, if the crime scene wasn't contaminated, wasn't secured, and it was now contaminated, the difficulty you have is you don't know who left the cigarette butt there. Was that somebody that came afterwards and attended the crime scene? Because if that person alleges that, well, then you've got a big problem as the police, because now your crime scene is not such that you can draw inferences from the fact that it's been absolutely uncontaminated and kept pristine. So it's not ideal. It could have a major impact on forensic evidence later on, and provided, of course, the accused has some sort of explanation for it. But at the end of the day, it could definitely impact negatively on the state's ability to prove the offense if a crime scene is not contained. Let me just say the converse. In many cases, the crime scene is not so important, because I might have two eyewitnesses that say that I saw you shooting a person. Now, in that instance, it's fine. But the moment you start dealing with forensic evidence, and keeping in mind that forensic evidence is these days the most important evidence for the state in many of these cases, then it becomes very important.
Mr. Du Toit, I want to now take you through a scenario that happened in court where the witness, that is Sgt Mthethwa, was now sort of introducing what has been described, of course, as hearsay evidence, where he said that Kelly Khumalo's mother was the one who actually said that the evidence, which was the hat that was found at the crime scene, actually belonged to the perpetrator. And it's at this point where the state cautioned Mr. Mthethwa to only tell the court about what he observed and saw as opposed to what he was told. There was an objection from the defense to say that will the state then be calling Gladness Khumalo to the witness box if we're going to start introducing what was apparently said at the scene to Sgt Mthethwa. However, the state was very reluctant to answer the question. In fact, decided that they were going to pose it in a different manner. Can we make any inferences from this?
It's difficult, Silindelo, to draw inferences from that. Suffice to say that the state must always present the best evidence that they have. And if the best evidence is Mrs. Mthethwa testifying about the fact that the criminal left his hat there, that is critical evidence for the state. And we would expect the names of all the witnesses to be included in the indictment, because the state usually provides a list of witnesses. So we can only hope that she's around to testify. Let's assume for one moment that she is not around for whatever reason. Let's say she's unavailable to testify. Well, then we immediately dealing with hearsay evidence, and now we have to deal with the exceptions to the hearsay evidence. Keeping in mind, hearsay evidence is evidence upon which the probative value, or the value that you want to attach of that evidence, is dependent on another person's testimony. So the moment somebody else must come and testify about something, it's deemed hearsay. In this instance, if that witness is unavailable to testify, then the court can admit it in the interest of justice. So the fact that the state has sidestepped this issue says to you either they want to call this witness later on, or they have no interest in having this admitted as hearsay evidence, and maybe the witness sprung it on them and by accident mentioned this. But it would seem that that could be crucial evidence. If we know, for argument's sake, that hair follicles was removed from this hat and it links with one of the suspects or the accused before court, then it becomes critical that we close that chain evidence. And that chain evidence would then be Mrs. Mthethwa stating that Mr. X left that hat there, and we know that or the hat was left by one of the perpetrators, and we can tie it with hair follicles and DNA testing to one of the accused. Then it becomes critical for the state. But time will only tell what evidence they intend to adduce.
Lastly, then, just quickly, Mr. Du Toit, can we make any inferences from contradicting statements made by witnesses when they're in the box?
Yeah, Silindelo, so we have to always remember that the credibility of a witness is considered on various legs. One, we look at previous inconsistent statements. For argument's sake, if I made a statement that's contradictory to my evidence in court, if I made a written statement that says X, Y, and Z, and now in court I'm saying A, B, and C, well, that could affect the credibility. And at the end of the day, when all the evidence is considered by the court and the court looks at the totality of the evidence, the court will then pronounce on the credibility of a witness and say, well, listen, this witness did not impress me. He had major contradictions. I can't accept what he was saying. Or the court could say, listen, there were some contradictions, but these contradictions are so minor that I would not be concerned about that, because this witness really had the hallmark of truth in his testimony. And for that reason, I accept this evidence. So it's too early to make anything of that, Silindelo. I think time will tell, and we will gauge that as we go along. And also keeping in mind the credibility of a witness when it comes to eyewitness reports and identification and stuff like that becomes a lot more critical than just somebody who attended the crime scene and maybe was around the crime scene. You know, I think that might be a telling factor for the state if their key eyewitnesses become very poor witnesses because of previous inconsistent statements.
Thank you so much for your time this afternoon. That is Mr. Marius Du Toit, a legal expert, just unpacking for us what's transpired in courts today, where we had, of course, the state's second witness officially taking to the stand and describing exactly their role following the death of Senzo Meyiwa. It's back to you, Bradan.
Thank you very much, Silindelo Masikane, there outside the North Gauteng High Court in Pretoria.